Hold tight, can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tuning every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces turn stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Good morning, everybody. Good morning. How is everyone doing this morning? Hope you guys had a wonderful evening. I have some news, some breaking news this morning. Well, it came out last night, and today I decided to go ahead on and tell you about it. As you guys remember, Ashley Merchant had filed a lawsuit against the district attorney's office regarding. Good morning, Gigi. Good morning. I've been missing you. Okay, sorry, guys. I hadn't seen Gigi in a while, so I wanted to say good morning to her. Sorry. But Ashley Merchant had filed a lawsuit against the district attorney's office in regards to the open records. She had requested some items, and they refused to give it to her. So the judge had just as of yesterday, gave her final ruling on that. And Miss Willis, the DA's office, has to pay up, guys. Ernestine, I agree with you. I don't know why everyone else have to abide by the law, abide by the rules, but I guess because of her position, she feels that she's above the law. I don't know why that she thought that she could just get away with it. Now it's costing the DA's office more money that they claim they don't have, because they just went to the commissioner board to ask for more money for different things, especially with the gang situations and stuff like that. So I don't know why she thinks that she can get away with it. But let me go ahead on and bring up the actual let me get out the way. Hold on. The actual ruling from the judge. Let me go back up here. It says, in the Superior Court of Fulton County, State of Georgia, the Merchant Law Firm, PC, plaintiff, versus Fulton County District Attorney Office, Fani Willis, in her official capacity, defendant, and the indictment number was 24 CV 001325. And it says here, final judgment and order. This is Judge Krause. Do you guys remember Judge Krause? She's the one who made a decision regarding Judge Glanville. Remember that, Judge? Okay. This is the same judge. And it says here, this matter came before the court for a final evidentiary hearing regarding plaintiff's Second Amendment compliant for injunctive relief and attorney's fee and litigation expenses pursuant to Georgia's Open Records Act, OCGA 50-18-70, Ora, and it says against defendants. Having considered the evidence at the hearing, heard arguments from counsel, reviewed at the relevant law, and being aware of the record as a whole, the court hereby enter final judgment as follows. Number 1, applicability of Open Records Act. This court previously found defendant subject to the Open Records Act, or Docket 89. That finding is supported by the Georgia Supreme Court's subsequent decision in Gonzalez versus Miller. A district's attorney's office is not only a subunit of the state government, it is a district legal entity recognized by law and specifically described by the legislature as an office, whatever the outer bounds of the term's office is used in the oral may be. A district attorney's office, listen, fits within those bounds. Meaning, and Ms. Willis, as the elected district attorney, is the ultimate custodian of her office's public record. So she is bound by duty to provide this information, Open Records Act, to whoever, whatever, public entity or attorneys or whoever needs these public record information, open record. She has to give it up. She is not above the law. It is a law that information is available to the public. The only thing that the public may not get is some personal information, like social security numbers and things like that. But that part can be redacted, But she was supposed to give the information to Attorney Merchant. All right. So, defendant have never asserted that the records sought were not public record. See? Public record. And were exempt in some manner from ORA. Okay? Therefore, the only remaining issue for the evidentiary hearing was to determine whether defendants have substantially complied with the obligation of the Open Record Act, ORA. 2, compliance with Open Record Act. Under the ORA, an agency or custodian of public records has 3 business days upon receipt of an ORA request to determine whether and how to produce or permit copying and inspection of the requested record. OCGA 50-18-70F. Within those 3 days, the custodian must either produce or provide access to the records. Propose a timeable for doing so, or specifically specify in writing the specific legal authority exempting such records from disclosure by code section, subsection, and paragraph OCGA 50-18-70 and 72H. Wallace versus Greene County. If the custodian fails to affirmatively respond to the open record request within 3 days by notifying the requesting party of determination as to whether access will be granted, the order has been violated. So, in any action brought to enforce the provision of this chapter in which the court determines that either party acted without substantial justification, either in not complying with this chapter or in intuitively the litigation, the court shall, unless it finds that special circumstances exist, access in favor of the complaining party reasonable attorney fees and other litigation costs reasonably incurred, whether the position of the complaining party has a substantially justified, shall be determined on the basis of the record as a whole, which is made in the proceedings for which fees and other expenses are sought. Although substantial justification is not defined in ORA, the term is used and defined elsewhere in the code. OCGA 9-15-14 considers substantial justification in determining whether attorney fees should be awarded. As used in that code section, lack substantial justification means substantially frivolous, substantially groundless, or substantially vexatious. In response to some of plaintiff's open record requests, defendants acknowledge these receipt of the request, but there is no dispute defendant did not advise plaintiff affirmatively within 3 business days for any of plaintiff's oral requests whether any record would be made available. Thus, defendant failed to comply with OCGA 50-18-70F and violated the ORA. Further based on the evidence offered at the hearing and the record as a whole, defendant's failure to comply was not substantially justified, and plaintiff is entitled to attorney's fee and litigation expenses pursuant to OCGA 50-18-73B. So, as noted during the hearing, defendants, through the open records custodian Dexter Bond, were openly hostile to counsel for plaintiff Ms. Merchant and testified that Ms. Merchant requests were handled differently than other requests. Oh, hold on. We have the record for that one. Hold on, y'all. Hold on. Got to stop reading right there. Hold on. Here we go. We have the videotape on Mr. Bond's hearing. Mr. Bond was in there. Here you go. There go Mr. Bonds right here, y'all. They said he was hostile. Let's go take a look. Let's back it up a little bit.
To this merchant to begin her questioning.
My name is Dexter Q Bond Jr. Dexter, middle initial Q Bond. I am a junior.
Great, thank you.
So I'm a junior.
Can you tell us what your job title is?
I am the Deputy of Operations for the Office of Fulton County District Attorney's Office.
Does that include being the records custodian?
Yes, among many things.
And before we get into the documents, I want to talk to you a little bit about the portal, how that's set up. If first, let's talk about at the time that I made the request in January of 2024. Was there a website link on the DA's website for open records at that point in time?
In January, yes, there was a link on our website, yes.
And when a person clicked on the link on your website, it took them to the county attorney's open records portal, correct?
Yes.
And there was a drop-down box if they went to that open records portal to request records from the district attorney's office.
And I can't speak to that because I don't request records from the district attorney's office.
Okay. So at some point in time from then till now, was that landing page from the DA's office website removed?
I don't have information to that. I don't know.
Do you know if the open records page, the page that the public would go to, if that link was ever altered?
Are we talking from, give me a time frame.
From January until now. So what we just talked about was in January. If I went into the DA's office website, I clicked on open records, it took me to the portal.
Yes.
A month ago, if I went on the DA's website, clicked, and there was no open records link at that point.
I cannot speak to that. I do not monitor that site on a daily basis. I do a lot of things for the office, but that is not mine.
Okay, so you cannot speak to whether or not there was an open records portal site or portal link on the DA's website?
No, I answered that question. There is an open records link on the DA's website. You will click the link, you can go into the portal, you can request open records requests as you do. Oh,
So there was one in January and there is one now, right?
to my knowledge, yes.
Do you know if it was removed at any time over the last 9 months?
I cannot speak to that.
Okay, thank you. Who could?
I don't know. I don't maintain that particular website. Once the information is placed in the portal, if necessary, to be elevated to me, and I do my job as the business records custodian. But as it relates to it sounds like, forgive me if I'm wrong, but I'm interpreting your question to be a little bit more, I don't know what you're asking me, but
I'm
I
trying
can't.
to ask how the public asks you for open records.
And I'm saying that the DA's office has a website. As you know, the DA office has a link that you can use. The DA's has once you click that link, it goes to a portal, which you have used several times. And once you go into the portal, you can put in your request. That's what I'm saying.
Are you able to testify if over the last 10 months that process has been in place?
I don't object just based on the fact that the availability of the link in the portal is not an issue in this case, and it's not an issue pertinent to whether the records were provided.
Ms. Merchant, is there a reason, is what you're really trying to get to that for the entirety of the last 10 months, Mr. Bond or someone else would be tasked with and subject to complying with open records? Or are you really trying to ask if there's an actual portal button on that website for the whole last 10 months?
I'm trying to figure out if they had, so once I made my request in January, I had to make follow-up requests and it went away. And I wasn't able to continue to make those follow-up requests, which is part of when we continue to make those requests.
Okay.
Forgive me, I'm gonna reframe your question and you make sure that I'm not reframing it appropriately, right? Your time frame at issue is from January to the present.
Yes.
And you are asking me at any time, did that particular process deviate?
Yes.
The answer is yes.
Okay.
May I explain?
Please.
Because of the cyber attack. I do know, if I'm familiar, that you received an open records request saying that, hey, we are under a cyber attack, this will require a delay, and I do know that this portal is not maintained by my particular office, right? I think you and I can agree with that they made
Why do they
some
talk like
modifications.
that?
So if your
The
question
DA's
is, look at 10 months, did something change from the routine? The answer is yes. The reason why is because it was a cyber attack.
I'm just gonna interject very briefly. You're like me, you're natural.
Wait, hold on, y'all. Why do they? Have you noticed the way any of them, when they get on the witness stand, how they answer question? They don't answer questions straightforward. They answer question in a weird sense. It's like going around the block when you can go straight across the street. You go around the block to get across the street instead of going straight across the street. Doesn't it seem like that, the way they answer? And they don't, it's like they play around, wordplay. Is it me, or do you guys find it the same way? Do you guys find it the same way? I'm just trying to figure out how they handle. Yeah, it's kind of weird. Okay, let me go ahead and play it.
Actually a fast talker, and for the benefit of the court reporter, she's already asked us once to slow down, so if you'll try to be more conscious about speaking slowly so she can.
The judge said he's a fast talker. In other words, stop giving me the going around the corner and up the block instead of just going straight across the street. Just go straight across the street, okay? No, none of that fast talking stuff. The court reporter have a hard time trying to figure out what you're saying anyway. Now, slow it down.
You can take it down, okay?
Yes, Sean.
Thank you, sir. Go ahead, Ms. Merchant.
And I just want to make sure I understand. So it changed because of the cyber attack. So that portal link was at some point disabled or not available?
So you asked me, did something change? I reframed the question to make sure that we were on the same page, right? I told you, yes, something did change. I gave you an answer as to why that did change, and that was as it relates to the cyber attack. Again, the framing of your question was from January to the present for the last 10 months, right? And enter in your question, you asked me something about the last 10 days. So forgive me.
10 months, I'm sorry.
You said 10 months, but you also said 10 days. I asked you a follow-up as it relates to the framing, right? I've answered that question from January to the present. I have told you that the reason why that has changed is because of the cyber attack. I've also told you that I do not maintain that website on a daily basis.
My question was, how has it changed? You said it's changed. My question is, how has it changed?
I cannot answer that question. What I can say
Wait a
is
minute.
that
Wait.
from 2021 to the present,
He is the lead person in open records, right? He's the boss. But he can't tell you how his department made some changes in their system. He can't give any information on that. That kind of tell me that you're not doing your job, sir, because you're supposed to know what's going on in your department. That doesn't make sense, sir.
the DA's office has had access that allow constituents like yourself to request open records. That link is displayed on our website. Once you click that link, you can go into the county's portal. I've also told you that I do not monitor that website on a daily basis. So if you're asking me how, I cannot answer that question. But if you telling me, look at the last 2 months, if it has changed, I am telling you, a cyber attack has required a lot of things, including open records, to change.
Do you monitor the open records portal?
Do I monitor on a daily basis? No.
Do you monitor it at all?
Yes.
How often do you monitor it?
On an as-needed basis.
As needed.
Yes.
How do requests come to you?
You go to the link, you put it in, it goes into the portal.
Oh, sorry, and just to save time, I'm not asking how I do it, I'm asking how they come to you.
Once a staff member on my staff, a designated staff member for open records request, receive the open records. If it's standard, like the many of you have supplied, we can go ahead and give you a responsive record, right? If it's not standard and it requires an elevation of some sort, then it is elevated to me by a staff member.
Elevated to you?
Elevated to me by a staff member.
So the first sort of triage is the staff member reviews it, determines that they can just answer it quickly.
I would say that, yes.
And then if it's something that's more elevated, can you describe what something more elevated would be?
I'll do it the opposite way if I can. if you're looking for an invoice, a particular invoice, and that invoice has been commonly requested, my staff knows that this is a particular invoice. And for efficiency purposes, we get that responsive document to you as quickly as possible. And then if you're talking about something that is exempt or possibly exempt, that's an example of something that's going to be elevated. And not in this particular case, but in some cases, my exemptions include open and active investigations. So in those particular cases, that'll be elevated.
Were my requests elevated?
You have to be more specific. You know, you gave me about 40.
Were any of my requests elevated?
Yes, ma'am.
Were any of my requests not elevated? Narrow down.
I'm going to say yes because 40 was not presented to me. I know that you are a frequent open records requester. I know that we have responded to open records requests. I am familiar that you, I would say dozens, and I would not say that all dozens have been presented to me. Those have been closed out based on my monitoring. So I am comfortable saying that all have not been elevated to me.
And you said I did 40 open records requests?
I said dozens, maybe 40. I feel comfortable saying dozens. I know.
They're maintained on the open records portal, right?
Yes, I'm pretty sure they are. So maybe 40, maybe 30, but I know it's a lot.
Would it surprise you that it was less than 12?
Oh yeah, I think I'll be surprised with that.
Okay, and let's go through them in a minute. We'll go through the specifics.
May I ask a follow-up? 12 an issue or 12 total?
In total,
Since when? January to the birth?
correct, since Ms. Willis was DA.
That would surprise me. That would surprise me.
You all have a.
I don't know,
employee manual
Sergeant.
that you use at your office, right?
Yes,
Right. And that governs, it also talks about open records requests.
I believe so, yes.
And if you want to look, we've got, these have been admitted previously. This is merchant 0602. I believe the county attorney supplied this, I'm assuming from your office. Does that look like, you can look at it on your screen, part of the employee handbook that's given to new hires that Ms. Willis created? Or I think it's
Mr. Bond's eyes maybe better than mine, but you might need to make it bigger, because my screen's pretty small and I'm
Yeah, it's
struggling.
hard to read.
So that's okay. Thank you.
Thanks. So does that look like the section regarding open records compliance?
Yes, at first glance, yes, 6.6, Open Records Act compliance.
Okay. And it says that all open records requests submitted by members of the public will be handled by the open records officer. Is that you?
It will be handled through the portal, so no, not necessary. It will be handled under my leadership.
Okay. And so handled under your leadership, but through the portal. It also says that DA employees should consider all communications that occur on county email, cell phones, and other county-owned technology to be considered open to a FOIA request.
Subject to no exceptions, yes. So I think that's consistent with the Open Record Act. I would
Okay.
agree with you.
Okay, so subject to no exemptions, county email and cell phone communications would be something that you would provide open records.
General rule, but I think you and I can agree certain things exception. I work with 385 staff members. Of those 35, about 150 or so are attorneys, and we know that there's exemptions. So anything that they're working on as it relates to attorney work product or confidentiality work product are exempt. So yes, this is the general rule, but I don't want the general rule to be mistaken as the norm.
Right, I understand, definitely, there's statutory exceptions.
You and I are same page.
The statute's the
And to
statute.
be clear, the employee handbook, while it is helpful guidance, doesn't change what the statutory obligation is one way or the other, so.
No, and the reason I'm asking him is the process in their office, to try to understand this process.
And if I can clarify, I think the second sentence is certainly important, right? I know that.
Oh my God.
Again, I alluded to the size of the office, 385 approximately. We want to make sure.
Caught me
that
off of that
staff members who
comment.
receive Open records requests know what to do with it. So that, I think that was the angle.
Okay, so the employees receive this and they are told that they need to forward it to legal counsel of the district attorney when they get something.
At the time of that writing, yes, legal counsel.
This is the current handbook, though, right? I'll represent it's the one that your office provided earlier this week through Ms. Monroe.
I would say yes. If your representation is correct, I would take that as this is the correct one.
And legal counsel, right now it's Ms. Abbasi, I don't want to say her name wrong. Alabi. Ms. Alabi is legal counsel now. It was Mr. Armstrong before, correct?
Yes, he was at one point.
Okay. So according to this, Mr. Armstrong or Ms. Alabi would be copied on all open records requests received by employees?
So, no, let me deviate. The answer to that is no. The reason why is we had several different legal counsels since 2021, and based on their strengths, weaknesses, or expertise would determine whether or not legal counsel will handle that. I had legal counsel before. That was his expertise. He felt comfortable handling it. I cannot say if Kevin Armstrong handled open records, so I want to be clear. As it relates to Andrea Alabi, a dynamic attorney, however, open records is not something that she handles.
So if a member of the public was reading this and at the time they made their request, Kevin Armstrong was legal counsel, it'd be reasonable for them to think that Kevin Armstrong would be apprised of their open records requests, assuming this is followed.
No,
No.
I don't think so.
Okay. This also, let's see, if we go down a little bit more, it talks about emails. Let's see, email communications. This advises employees that emails are monitored, and essentially that means that you're telling them you have access to emails, or the office has access to emails, correct?
You have to tell me the line. The way that I read that is my district
Oh my
attorney
God,
Fani Willis
no.
requires us to look at emails. So,
It's so
3 times
difficult.
a day is our standard.
If you look under section 6.9, the third line, it says to ensure compliance with this
Good
policy,
morning,
computer
everybody
and
that's
email
coming
usage may be
in. Good
monitored.
morning.
Does that mean that the district attorney's office can monitor computers and emails?
Not necessarily, well, can we? Yes.
Can, that was the question.
Yes.
Okay, what we're looking at right now is Mr. Bond's testimony, because Judge Krause did mention him in the final decision of the final judgment, and we wanted to see what type of testimony he gave and how his demeanor was and how uncooperative, or whether or not he was trying to help in the situation. And so far he seems like a real piece of work. That's all I'm gonna say. I'm gonna say it nicely, a real piece of work.
Okay, so you have access to emails?
Yes. I do
Okay.
have some. Let's
Okay.
put
Some.
some emails. Yes.
Access to county files? On county computers or county phones?
Yes.
So on a county computer file email system, you've got access to emails.
When you say you.
Your office, I'm sorry.
Okay.
And when I say you, it's been represented, and we can pick a term if you want, but as that you're the man for open records. You're in
Okay.
charge of all of this. So
So the answer to your question is, as in you, as in Dexter, right? Yes, I will have access to that.
Okay.
Or I will request access. Is that better?
yes.
Okay.
And so this also, if you look at, let's see, after where it says only those who are directly supervised by the district attorney can send emails directly to her. So is that policy that someone who's not supervised by her is not permitted to send emails directly to her?
We have a strict chain of command, so I think that is true.
Okay, so it's reasonable then for a member of the public who was trying to see emails to assume that emails would go through a supervisor before they went to the district attorney.
That would be a general practice. I think so.
As an open records custodian, part of your job is to be familiar with the rules with record retention, right?
Yes, to a degree.
And so you've got to, and that's actually in the, if you look on the same page, if you go up a little bit, there's a policy for record retention, and it says that all records are maintained in compliance with the state of Georgia's retention schedule. Would you agree with that as the policy of your office?
That is the policy.
So any records that the public is trying to access, they can assume based on the policy of the office that you're going to retain them based on the state of Georgia's retention policies.
That is an accurate assumption based on this policy.
Okay. While we're on this document, if you flip to the next page, 0603, it talks about county cell phone policy. It says that all investigators or attorneys are required to have a county cell phone, and that text messages, recordings, and photos within that cell phone are the property of the county. So that means that if someone did an open records request for those types of documents, that's in the county's property, right?
This is what get here. As it relates to Fulton County's property, the answer is yes.
So it says they're required to have a county cell phone. So an attorney is required to have a county cell phone. Let's use an example. Jeff DeSantis is required to have a cell phone, county cell phone, correct?
He doesn't work as an attorney in my office. If you're going through your analogy, give me an attorney. I can't speak on it for Jeff.
And I'm looking, it just says all investigators and attorneys.
And Jeff is an attorney.
He's not an attorney?
I don't, in the capacity of my office, no, he doesn't act as an attorney.
So
An ADA, yes, is required to have a cell phone. An investigator.
are you saying that Jeff DeSantis doesn't have a county cell phone?
No, I'm not saying that. You presented the analogy that all investigators and attorneys are. I understood your analogy. You gave an example of Jeff DeSantis. If your analogy is investigators and attorneys, I want to keep you honest, and I'm letting you know that in the capacity of Jeff DeSantis, he doesn't follow either category. So I'm following you, and I offered you an opportunity to present someone else, and I gave you an idea of an ADA, because the ADA fits with your example.
Let's back up for a second.
Okay.
Jeff DeSantis, and I was just using him as an apparently unfortunate example. He is the deputy district attorney, correct? That's his job title.
His working title in the office is public relations.
Can I personally district?
Sure.
Thanks. Showing you a printout of the district attorney's website. You take a look at that and see if that refreshes your memory as to what Jeff DeSantis' official title is within your office.
Deputy district attorney,
Thank you.
overseeing the media relations unit.
Thank you. So the policy that we're looking at, county cell phone, says all investigators and attorneys are required to have a county cell phone. You're saying that not all attorneys and investigators are required to have a county cell phone. Is that accurate?
That's not what I'm saying. You gave an example of Jeff DeSantis. I could not speak specifically as it relates to Jeff DeSantis. I'm not arguing whether or not this policy exists. All investigators and attorneys are required to have a cell phone.
Okay.
That is correct.
Okay, so all unnamed attorney has a cell phone. According to this policy, if that unnamed attorney on their county cell phone is messaging on an app on their county cell phone, and they're recording things, and they're taking photos, screenshots from an app, that's subject to the open records request.
If there's no exceptions, yes.
If there's no exceptions, thank you. Okay, let's move on to one of the requests that I want to talk about, and I have a couple different identifiers if you need them, but it's the critical mention media monitoring. Oh, do you know if Jeff DeSantis has a county cell phone?
No, I do not know that.
You do not know that. Who would know that? I'm assuming him. Anyone else?
I don't know.
Okay. All right, so let's move on to critical mention media monitoring. If you need me to tell you the request, the open records number request, or exhibits or anything, I'm happy to do that. Just let me know, okay? But I'm going to globally refer to them as critical mention media monitoring.
Okay, I'm gonna stop you here.
Mhm.
I know that we have a lot of critical mentions, so I would prefer, for the clarity of this court, to make sure that we're specific on critical mention, because I know there's multiple.
Not a problem.
So
There are
don't-
two.
So my ask is don't globally refer to them as critical mention. If that's
I will
okay
not
with you.
What?
Can you pull up merchant 0027, please? There are two requests. This
Hey,
one,
everybody is coming
just for
in.
your clarification, ends in 010924. This is my first open records request. On January 9th, I requested any and all correspondence, as you can see, to or from critical mention, including copies of contracts, payments, analytics, reports to or from critical mention and any member of the district attorney's office. Would you agree this request is pretty clear and concise?
Based on my reading, yes.
And I submitted it through the Fulton records, the Fulton County Open Records portal.
January 9th, yes.
And it was received January 9th. It says, if you scroll down a little, it shows it was received that day. That's when they return it with the reference number, that is saying that it was received.
That is correct.
Can you repeat what page you were referencing?
I'm so sorry. Yes, it is a merchant 0027. And it acknowledges receipt of the open records request, correct?
On January 9th, I received that via the portal. We acknowledge receipt because you have a reference number. That's yes.
Okay. It doesn't say anything about whether responsive records exist.
Not on January 9th. That's the day I received it.
Doesn't say anything about proposed costs or when the records will be made available.
On January 9th, when I accepted it, no. I think that you have requested several open records requests. You have given them, you've been given all the records, right, that we closed out free of charge. So there is not anything from my office that would have a cost because I did not charge you on any open records requests that you provided.
I didn't ask that.
That's not what she asked.
Any proposed costs.
She didn't
Does this
ask.
provide any proposed costs?
On January 9th response,
This document.
this document that you put before me, January 9th, I acknowledge that it is a receipt number for tracking purposes. It is a acknowledgement of receipt and it's a description of the records you requested.
If you would scroll up, so on January 12th, someone wrote back, or I wrote, thank you, and I followed up saying I was asking for the analytics, the contract, and the analytical reports. And I was asking, following up, when I could receive them.
3 days later, yes, it appears, I don't know, Ashley Merchant wrote, thank you, in follow-up. I also asked for, yes.
Okay. And then on January 11th, someone, either from your office or the county, said, please log into the portal and see attached emails, correct?
January 18th.
January 18th, I'm sorry, if I said it differently.
So January 18th, based on this email,
Okay.
we gave you attached emails, and included in those emails, there were several different documents. So yes, I responded to this open record request on January 18th.
Did you type this or did someone else? Please
I did
log
not.
into the portal.
I did not type that.
The attached emails, did you provide those attached emails?
No, I did not.
Who provided those attached emails?
A member of my staff. A member of my staff. I do not know who provided that on January 18th, but I do know that.
What? You're the boss, but you don't know which staff members provided that information?
This particular request, as you said, was pretty straightforward. So we responded and it was closed out. This wasn't elevated to me.
So you never saw this request? You were not involved in this request at all?
On this particular request based in the portal, I don't recall this being elevated to me on January 18th, no.
So you can't tell us what searches you performed looking for these documents?
I can't tell you that.
You can.
Yes, this is a general request. It wasn't elevated to me. Critical mention is something that was always asked. I have several requests that are very similar to this. So I'm pretty sure, not this particular one, but one of critical mention was elevated to me and we responded the same way we did with most critical mention.
Who did you ask?
I'm sorry?
Who did you ask in response? You said you did ask somebody about these records. Who did you ask?
So with critical mention, you ask, based on this search, you will look and you will reach out to Jeff DeSantis. Hey, do you have any emails related to critical mention? After that, you will go to the IT department to confirm,
Okay.
see if they need responsive records.
Fulton County IT department.
Yes,
So Jeff DeSantis and Fulton County IT are the two. Okay.
especially when you had to put emails, the answer is yes.
But you don't know if you did that in this case.
I know that I did that in critical mention. I have 1,000 cases. So as it relates to this specific request, I cannot tell you that this particular case was elevated and this was on the top of my list.
And once someone makes a request like this, what steps do you take to ensure that the documents they're requesting are preserved?
I'm sorry, yo. I had to laugh at that one because I mentioned earlier that how is it that they all act the same in that office when they get in on a witness stand? And it's like, they've been like cloned or something to answer questions that way. And I was like, I just started laughing. That's why I laughed at your comment. Thank you for that comment.
Oh, repeat that?
When someone makes a records request like this, as an example, what steps do you take as the records custodian to ensure that the documents they're requesting are preserved?
They are placed in a portal. Once the portal is sent to you, I think that you have access to that, and I think that that is something that the portal does to make sure that it is reserved. And I can have a copy if I needed to go back to those specific documents. So as it relates to you, this is when you and I are going to make sure we're not splitting the baby. But as it relates to the portal, they are reserved.
And we'll use this as an example and sort of walk through the request. So once you get a request like this, whether it's elevated or not, what are the steps your office takes to make sure that the documents I'm requesting aren't destroyed?
Typically, once documents that you're requested are placed in a portal, the portal, right, will maintain those particular documents, right? You have an email version, electronic file of those versions, so that's in the portal. So
So, and maybe I wasn't clear. So you're telling me how you maintain the documents you give me. What I'm asking you is when I ask for critical mention documents here, okay? And you get this request and you give me some of them. How do you make sure that they're all maintained? Where do you all maintain them?
I'm gonna answer your question, I'm gonna make an assumption if I may, okay? I made a comment and I said that there was 40 open records requests. You looked and it appeared, assumption. Emphasis on assumption that you was gonna go see how many open records requests you had.
Right, it's all there.
Yeah. So the answer to your question is, it's in the portal, it's all there.
No, that's why I didn't know if you understood my question. My question is not,
I
how
just
do you
repeated
preserve
you.
your
Hang on,
response?
don't talk over each other because the court reporter can't take it down.
My apologies.
That's okay. Ask your question and then you are free to respond in any way you wish.
I'm not asking how you preserve what you tell me you have. What I'm asking is how you preserve the documents inside of your office that I request, not the ones you give me, but the ones I've asked for.
If you ask for 5 invoices, right? I'll take those 5 invoices. Those 5 invoices is given to a staff member to provide to you. So the original copy of those invoices maintain where they are, right? You have a copy that's filed electronically, right? It is given into the portal. So if I understand your question correctly, 5 invoices. The 5 of those invoices are sent to someone on my staff. A copy of those invoices are uploaded to the portal. Those 5 invoices, the original copies, wherever you came from, continue to stay there. Did I answer your question?
Yes, so
Okay.
the originals continue to remain wherever they originally were.
It depends on the particular document. If you, in my example, I gave you invoices.
Right.
We do know that invoices are electronic, right? Well, I like to think that most invoices are electronic. So in those particular invoices, wherever they are on my particular file, they stay. A copy is employed to my staff member and then uploaded to the portal.
And let's go through some specific things that you gave me, and then we can sort of go back to that question because it might help.
Okay.
If you look, let's see, if you can pull up merchant 0029, on January 18th, there was, I received this packet that we talked about of emails uploaded to the portal. What you're looking at is the beginning of that packet, and it was 44 pages. That was in response to my original request discussing critical mention. You said you did not produce this document, correct?
No, I don't believe so.
Did you assist in retrieving these documents?
For these particular documents, no. These documents appear to be responsive to your open records request. It appears to be delivered to you on January 18th, and it appears to be responsive to your request.
You can look at 0055. If you go down a little on this one, see where it's after Melissa Fritz, it says Fani Willis critical mention search. It's a different font, and then PR value for the week, and then there's a couple other things. This, and we now know, because we have the actual emails, we now know this is 4 or 5 different emails that were pieced together. Did you participate in the cutting and pasting of these documents?
Objection, Your
I
Honor. Objection, Your Honor. Presumes that he cut and paste documents, and that was never established by his testimony, so we're objecting to that.
Okay, well, for now, I'm gonna sustain your objection to the characterization of the cutting and pasting. But you can certainly ask him if he participated in the creation or generation of this document that was produced to you, however it came to exist. So your objection is sustained to that extent, Ms. Monroe.
And Judge, I thought that was Mr. Bowman's witness. I might be mistaken, but I prefer not to text him.
Well, I do agree, I apologize. Who is going to be examining this witness?
I will.
Oh, okay, well then, fair enough.
I didn't know that was a thing.
Well,
I mean,
Mr.
generally-
Bowman had objected, so.
Yeah, generally speaking, you know, whoever's going to be examining the witness is the one who should be controlling the objections. And I think Ms. Merchant's expressed concern was she thought Mr. Bowman was gonna question this witness, which would make your objection problematic. But since you're gonna be examining the witness, it's fine.
That's fine.
I'll frame for the honor.
Usually I just ask that you whisper in your partner's ear so they can then say the thing that you want them to say.
And I showed Mr. Bowman the documents because he had made the first objection, so I just was assuming that was the path, but I will check. Okay, so this document, however it was created, did you assist in the creation of this page?
No, I think you and I agree that the first request was straightforward. I don't think that this was elevated to me. On January 18th, no, it was not elevated to me.
Who compiled the document in the form that we see it in here today?
A member of my staff, that's an assumption, a member of my staff.
Okay, so you're assuming you don't know who compiled this?
Specifically,
Yes.
on January 18th, yes, this is a designated employee, yes.
You're positive it's a designated employee?
Well, okay. Yes, I'm positive I know who that is.
Who is it?
Erica Willingham.
Erica Willingham. So Erica Willingham is who we would need to ask, not you as the records custodian, about how this document was created.
I cannot answer that question. Let me explain why, right?
What?
Typically, emails are compiled in a certain kind of way, right? And those emails are compiled by IT, by staff. It may be compiled by going to reach out to various different persons. I cannot speak to that, so I cannot tell you if she personally, if the question was, did she compile? I do not know. I do know that she handled it as a member of my staff. I do know that she responded as a member of my staff. I can tell you that.
So you can't say as the records custodian that this is an accurate copy of an original document. Let's put it that way. You really don't know anything about this document.
I do know something. I know it was responsive to your request. So yes, I know something. I can agree on that.
You know something,
Let's
y'all.
take a look at, I'm gonna jump out of order, I apologize. If you, let's see.
I also know, if I may, that it was provided to you on January 18th. I also know that you received this particular document on January 18th. I also know, as you mentioned, that there was a second critical mention document. In that second critical mention, I know you referenced this before, right? I also know that once you referenced this before, you renewed a second critical mention document saying, hey, you gave me this on January 18th, I'm looking for A,
Yes,
right?
and we're in
And
there.
that's why you and I on the same page, didn't want it to be global. So I do know information as it relates to this particular request.
And we can actually go there right now. So I filed a second request because my initial request was closed when you all provided this 44-page document, right?
Yes, on January 18th, it was closed.
And so on January 18th, I refiled my request and I specifically referenced the original one and said, why are you closing this? You didn't give me everything. Did you?
If I can,
Yes,
I like the fact that you presented the first one and allowed me to read it. Can I read the second one?
of course, it is, let's see. I don't have the number off. The second one is. Merchant 0011. Can't take a minute. Oh, doesn't take a minute. There we go. So this one I said in regards to my prior request, and I referenced that number we just talked about, and I said I requested the critical mention documents, and I say the number. I said, I got a set of emails, but I asked for the analytics and the documents that are clearly referenced and attached to those emails. I said reports with analytics were provided to the DA's office monthly. It appears from the emails that Jeff DeSantis, Fani Willis, Jeremy Murray, Pallavi Perkasa, Robin Bryant, and Rita Kepler may all have access to these reports on a regular basis. They're public media, paid for by public funds and subject to open records.
Yes, I did receive that. This was elevated to me, and I did respond to you.
Okay, so this one was elevated to you, and you definitely did respond. Before we get there, let's talk about what we were just talking about a minute ago about the I don't want to use the word cut and paste, the document, and I'm going to call it Merchant 55, that appears to have a compilation of several other emails contained within it. Okay, that document we were looking at a minute before, and you said you don't know who prepared that document, right?
I do not know who compiled that. I know who handled the file. I know who sent you the responsive document.
And you don't know where that person got the responsive documents. But you assume it was Jeff DeSantis, is what you said earlier.
I did not say that, ma'am.
You said you would reach out to Jeff DeSantis and Fulton County IT.
But he certainly wouldn't compile any documents for me.
Oh, okay.
Okay?
So who would compile them? Who would, and let's just look then. So you've seen, and can you show him again, Merchant 0055, just take a look at this document. So I'm gonna ask you to compare it to a different one.
Okay.
So just to make sure I'm clear, I thought that Mr. Bond said that he believed that Erica Willingham was the person who compiled the response at Merchant 0055.
I thought he said that she did, but that she would reach out to Jeff DeSantis and the county. First, he said he didn't know who provided it. He said that they would reach out to Jeff DeSantis and Fulton County IT.
Well,
and then
that's
later,
actually why I'm asking for clarification, to make sure we're all having the same conversation, because I understood you to be asking him about who compiled the document that was provided to you, not who obtained the information that was then determined to be responsive and compiled into a document that was provided to you. What I understood Mr. Bond to be saying was, this type of request, I would have reached out to DeSantis and maybe County IT, and then it was compiled by this particular employee and provided to you.
okay. And I'm not sure. That's the ultimate question. So let me try and be a little more clear then. This document, number 55, okay? It looks as though it's a compilation of other emails, okay? If you look after Melissa Frick's name, it says Fani Willis critical mention search, and then PR value for last week, and then there's that middle section that we're talking about, middle section right here. There's no header to, from, or dates here. There's no header to, from, dates here. There's no header to, from, dates there. That, they all look like different emails, right?
I would agree with you.
Okay, so not using the word cut and paste, someone took these parts and put them all in one.
Objection, Your Honor. Is that a question, is a statement? I mean, if it's a question to
Well,
the,
he's an adverse witness, so she can cross-examine if she wants to, number one. Number two, the reason I said we were not gonna call it cut and paste is that assumes facts that are not yet evidence. Now, you can ask questions about assumptions that you're drawing from the appearance of the document, but that's why I said we're not gonna call it cut and paste. Now, I think the witness has called it a compilation, so why don't we call it that for a while until we decide that it's something else?
So this appears to be a compilation of several different emails into one.
I agree. Compilation, yes.
Okay.
Compilation is cut and paste, y'all.
We're gonna learn from you, Paul. What were you gonna say?
No, I'm agreeing with you. That does appear to be.
Compilation is putting two things together. I mean, a few things together, right? That usually taking whatever the other email is and putting it into the other one, and it's cut and paste, isn't it? I'm just saying, compilation in one, cut and paste.
Be a compilation of emails.
Okay. And can you pull up Merchant 0167? So there's a redacted section here, and then you can see under that, I sent a story via critical mention a few minutes ago, directly below. Okay. So this, and this were removed from that email. It just starts with I sent a story via critical mention. All of that is not in that compilation document, right?
As it relates to the headers.
As it relates to the, sorry?
It's-
Yes.
It does not appear to be so.
So this was all removed. And the document just starts right there.
I cannot tell you if it was removed. I think my testimony, Your Honor, is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say, 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3, 4 was resolved, that is closed. And I responded on January 26th to the remaining issue. So as it relates to
He's getting a little
compilation,
testy now. Sound like he's
I want to be
upset.
very clear. It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved, and the only outstanding issue related was analytical drafts embedded into something, which I responded to you on January 26th.
Wait, if he assumed, why would he assume that it was resolved when she said, why are you closing this out when I have not received the information? That's what she said in that email. That's why she reopened it and said that it had not been resolved. And why are you closing it?
Is that clear?
No,
Okay.
and so let me break it up because there was a lot, so I tried to take notes. First, you said I accepted it. So on January, whatever the date was, 18th, I accepted it. When you said I accepted it, you sent me a document and I accessed it and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I am also saying that you opened up another open records request.
Why?
In your second open records request, that's why it's very important we do not refer to this as globally. You make reference to the first.
Yeah.
You said here in court that the first one was very detailed, in which I agree. Okay? I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there's one thing outside, I am a reasonable person, that's the word that you use, will assume that the first is over. It's done. It's complete. So I am assuming,
What they say when you make it soon.
that you accepted the open records request because you said, here's a second one. I did this. I'm referencing that, and here's a small section.
So you assumed I accepted it and.
It was
Hold on.
delivered.
Hold on.
Is that better?
Delivered.
It was sent to you on January 18th.
Yes.
No, there is no reason to argue about semantics of what we're talking about. It is not in dispute that on the whatever day it is that the Open Records Act portal sent you a batch of documents. And then I don't think it's in dispute that that request was closed and then you followed up on it, which the county or the Fulton County, whatever we're gonna call it, treated as a new request that referenced a prior request. We don't have to argue about whether it was accepted or received or acknowledged or whatever. The facts are what happened. Let's move on.
So you said that it was, that was responsive to my request, but it didn't completely respond, it only partially responded to my request, the first one. The 44 pages weren't all that you had.
Yes, Your Honor, is that a question or a statement?
It's a question. The 44
Okay,
pages.
hang on. When there's an objection, let me deal with it. We're just gonna put a question mark on the end of Ms. Merchant's statements, because technically that's what they are, but they are allowable cross-examination questions, so.
Right, but I want to put the witness in the best position to answer the question, so if it's not posed in the form of a question, I think that's, the onus is on her to pose it in the form of a question as opposed to a statement.
I think that right now I'm gonna, unless I believe that it's being deliberately confusing, which so far it is not, I'm going to allow Ms. Merchant to question the witness. And I'm gonna overrule your objection for now. Go ahead.
Thank you.
You have to repeat your question, I'm sorry.
The 44 pages that you sent me on January 18th, you said that they were responsive to my request, but they were not complete. There were additional documents. Now we have 197 pages. So 44 were only partially responsive. Is that correct?
Okay, I have issue with your question, so let me break that down, okay? As it relates to you, I have testified that on January 18th, a member of my staff responded to you and provided you responsive documents, okay? So you as in Dexter Bond did not give you anything, okay, on January 18th. The responsive request for your records that sought 5 things were given to you on January 18th. The answer is yes. On the next day, as you just testified, a new open request was opened. You made reference to the first request, right?
He's not
That,
testifying,
again,
sir.
The first request was 5 things. You only asked about 1 thing. The first one was never elevated to me, okay? The second one I responded to on January 26th.
Round and round and round.
So my question, to answer my question, the 44 pages that you provided, your office provided on January 18th, that is not all the documents that were responsive to the original request. It was only partially what was responsive. Correct?
At the time on January 19th, I couldn't answer that question. I don't know. I don't know.
So you gave me documents, or your office gave me documents, and then you have now certified 10 days ago that 197 pages are the actual.
2 different things.
Yes.
So I'm glad that we was
So,
able
and
to
hold
talk.
on, so now we've got 197 documents.
Okay.
Back then we had 44,
Let me,
okay? Hold on. Those 197 page documents, those existed in January when I made my request, correct?
I cannot say that.
You don't know if they existed?
May I respond?
If you answer my question first, I'm happy to allow you however much time you want to respond.
Okay.
Did those documents exist in January? The 197 pages? Your business record certificate?
I cannot answer that question. May I explain?
Why you can't answer it?
No, let me explain why I cannot answer it. That's correct. Let me explain. Your open records request as you presented asks for certain things, right? I'm assuming that you are talking about the production of documents that you gave on August 30th, right?
Yes.
All right. In that production document, I'm assuming you're saying that that was 197. What I am saying that I cannot correspond, because it's my assertion that the open records request that you received on January 18th is different in scope from the subpoena you requested. And because there is a difference in scope, because your subpoena was more specific, I cannot tell you if the two are correlated. So I cannot answer your question.
So you can't tell me if the 197 pages that you provided on August 30th, if those existed in January?
Yes, they would have existed. The 197 pages should have existed. However, I cannot tell you, let me be very clear, that the 197 pages that you received on August 30th as a response to your subpoena was responsive and should have been included in the 44. I'm afraid that you are looking at an open records request that you received on January 18th, accepted with no reservation. You're convoluting a subpoena. There's 2 different scopes. There's 2 different, your search terms were different. So yes, the 197 did exist in January 18 because the scope in which you asked for was from January 2021 to the present, whenever the subpoena came in, right? We did that through IT. Those documents you could certify. I cannot tell you if those 197 were responsive to the 44 because your open records request and your subpoena are different. Your subpoena is more specific.
Okay, so my open records, my first one said that I was seeking a copy of any and all correspondence to or from critical mentions, copies of contracts, payments, analytics, and reports, okay? So correspondence, that's emails.
More.
Correspondence is emails.
And I gave you emails.
The 44 pages versus the 197 pages. Would you agree with me that there are a lot of emails in the 197 pages that were not contained in the 44 pages? A lot of emails. We can go through them page by page if you'd like.
If that's what you prefer.
It is not. It's
Okay.
definitely not.
What I am telling you, and I need to be very clear, that your subpoena that produced 197 pages, right? It required, look at this particular email to and from, right? As it relates to these particular search terms. So your subpoena was filled out and given to the Fulton County IT department, and those 197 pages were given, researched, and provided. Let's look back at your open records request. There were no search terms. If I am not mistaken, and you may have to bring it up to reflect my memory, you just wanted something about to and from the vendor or something like that. They are two different things, two different scope. So if you're making an inference of 44 versus 197, I cannot buy into that inference because I see logically why 197 and 44 could be different.
And I'm trying to break it down simply so that we can just get through one item at a time. My original open records request, we're only talking about correspondence. You and I agree correspondence includes emails, correct?
I agree.
Okay. And would you agree that the 44 pages did not contain a lot of emails that the 197 contained?
I can concede that.
Okay. The next classification is contracts. Okay, so I asked for contracts between the DA and critical mention. Okay, would you concede that the contracts I got in the 44 pages with my open records request did not contain all of the contracts I got in the 197 pages? Would you concede that?
No, I cannot concede that. You have to show me that.
Okay, that's not a problem.
You
Which
have to
one?
show me that.
So we'll break it down even further. In the 44 pages, the original request, you only gave me a contract for the first year of critical mention, correct?
Show me.
Okay, let's see.
Tell me.
Okay, the 44 pages start at, just so everyone knows, they
Yeah.
start at merchant 0027. And that one may take a few more minutes to get up because we didn't have that one queued. Oh yeah, 0027.
We're not gonna get anything.
And if you want a hard copy of the documents, I can give you that as well. Okay, in response to that, if you go through the next couple pages, is it easy to pull up the next couple pages? Yeah, let me give you the exact page. It's actually the next page, 0028. And I didn't have that one queued up, but we'll have it in a minute, sorry. Or I can just show you.
That's fine.
It's 0028. Okay. That's the February 2021 contract for critical mention. Oh, there we go. They're up.
I'm glad you said that. I'm glad you showed me this isn't a contract.
No, this is not. This is part of it, and if you go through.
You and I just had a conversation about emails. I conceded. Now you're talking about contracts. I told you to show me. Now you show me an invoice. Which is it? Do you have a contract?
Judge, I mean, I don't care if he asks me questions, but I don't really think it's appropriate if he asks me questions.
Well, I'm not, you're not obligated to answer the questions he asks you. I would just encourage everybody to try and maintain a tone of civility and let's move on.
Yes, Sean.
So, go back, the 44 pages. I'm gonna give you the 44 pages, okay? So you can just look at those, we don't have to go,
Are you gonna point out the contract in the 44?
give me 1 second.
Oh, okay.
Okay,
I'm sorry.
so my open records request to you asked for contracts. Okay? That was one of the classifications we just talked about, right?
Yes,
Okay. Show me where in there you gave me contracts.
I did. I don't believe it's in here. You could not show me. So do you want me to go page by page? Because you said that you was gonna show me.
I want
You
you
gave
to
me
tell
an invoice, right?
Okay.
And then I said, all right, the 44. So now I can go through here to determine a contract. So you put, I'll do it.
So
But you said that you was gonna show me.
I'm gonna show you the one you gave me,
Okay, no.
but that's in the second
You were
request.
talking in the context of these 44 pages. You told this court that I gave you a contract. I said, show me. You approached me with the invoice.
You gave me
I
that
told
invoice.
you-
Okay, stop. Both of you. The question I think is pending that will actually help us move forward is that Ms. Merchant asked if any contracts were produced in the original 44-page production.
Yes.
And while none of us will necessarily enjoy that endeavor, it is perfectly fair for a witness to say, let me review the 44 pages and then I'll answer your question. And so if you would like to do that, you feel free to do that. But the question is, was a contract produced in the initial production of 44 pages? Because I think we had agreed that contracts were requested.
Yes.
Okay, go ahead. Mr. Bond, if you want to go through the documents, or if you want Ms. Merchant to direct your attention to something, we can do that, but the 44 pages is entirely fair for you to say, let me look at these documents before I answer your question.
Yes, I would like for you to direct my attention as you said you could.
Oh my God.
I'm asking you to answer the question the judge just asked you that I originally asked you. That I asked you if you gave me a contract in January. We agreed that I asked for a contract, okay? So we agreed I asked for a contract. I want you to show me where you gave me a contract. Or if you didn't, tell me you didn't.
Okay, allow me to review.
Great.
This invoice. Based on what you presented to me, assuming that there are 44 pages here, no, a contract is not in this.
In the 197-page document that has your sworn certificate on it, did you provide me with a contract?
May you direct me to that contract?
I'll give you the 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete. Give me a moment to reorganize. Let's see. Would you prefer it on the screen or in person?
In person, please.
I'm gonna give you one of them as an example.
That's why as an attorney, you got to be very organized.
Yes, and you don't have to ask every time.
Thank you.
You got to be very organized.
It's called a renewal of court to title.
Ms. Merchant, I'm sorry, I can't hear you when you step away from the podium very well.
Sorry, thank you for reminding me of that.
The renewal statement of work, if this is in my file, here you are, this is a contract.
It is. Okay, so what I just showed you was the contract, one of the contracts for critical mention, correct?
You showed me a renewal statement of work.
And that was not provided in January of 2024, correct?
It does not appear to be so.
I'm gonna show you another, I'm sorry,
And if I can, before I know you're about to move on,
I'm not.
we agree, right, that there were some emails, right? We also, as it relates to the contract, you said that
Nancy,
you,
funny.
that there
If
was some
somebody works in
documents
her
in that
office,
particular file that you have in the 197, okay? You also can agree, I hope, that on the second open records request, you brought forth, that was elevated to me, hey, Dexter Bond, I'm only missing with the analytical. So you and I can agree that any contract or anything was not in your, any open records request. We can agree to that?
No, we cannot. Can you pull up merchant 0055, please? we just had it up, I'm sorry, 0008. I'm seeking a copy of any and all, including copies of all contracts. That is my original request.
Yes, but you received this on January 18th. On January 19th, you said, you referenced this same open records request, right? And you said, I am only looking for, I received your request, you acknowledge receipt. I am looking for the analytics inside that.
I'm not talking about that yet, and we're gonna be here all day if we go and talk off track. The first open records request, this one, first one, I asked for contracts, okay? I just showed you a contract that you gave me on August 30th. That contract was not provided in response to this open records request, not a follow-up, in response to this open records request, correct?
The answer is yes, that contract was not provided in January 18th.
And here's a contract for critical mention for 2021 to 2022. You take a look at that.
Yes.
That contract was provided August 30th, but was not provided in response to my open records request, correct?
This statement of work appears to be provided in August 30th.
And you certified the documents that you provided August 30th. Do you have any questions about them?
No, I certified the documents on August 30th, but what I need to be clear is once the matter on January 18th was not elevated to me. I think that we're clear on that. When it came to January 26th, you requested 5 things. There was one thing in your second open records request that you brought to my attention. That was elevated to me. I assumed that on the 44 pages, everything else was responsive because you do a good job when you don't get something, bringing it to our attention. We do a good job of responding to you. So yes, you asked for 5 things on January 18th. My staff gave you 44 pages. When you brought forth the second critical mention open records request, of those 5 things, you brought forth 1. That one thing was elevated to me. So we make mistakes. If I did not give you a contract on January 18th, I would have loved, as I often hear from you, to get, hey, you're missing this, just like you did on the critical mention analytics square. You did not bring that up.
Judge, this is not responsive to my questions. I mean, at all. Not even close to responsive.
I generally try to let the witness answer the way that the witness wants to answer. I will, however, say that I think we are getting bogged down in what previously did or didn't happen based on people's characterizations and understandings rather than, and I think one thing that would help, Ms. Merchant, is if you would ask short, clear, direct, factually based, and not argumentative questions. And then Mr. Bond will do his best to give short, concise, factually based responses that are not argumentative. Because I understand that both of you have a position that you wish to vindicate about what you did or what you think did or did not happen here. But we need to set that aside. Go ahead, Ms. Merchant.
Just asking you about my first request. We're on to the third category, payments. I asked for payments. How critical mention was paid, correct?
You asked for contracts in or payments. Contracts in or payments on January 18th.
In this open records response, did you give me payments for critical mention?
I gave you 44 documents that I believe was completely responsive to your request.
Mr. Bond, you did not give me a copy of the payments for critical mention.
And when I reviewed the 44, I did not see a payment.
And you also did not give me any analytics, correct? In response to this one, just this one.
On January 18th, no, I do not believe, When you say analytics, I don't even know what you're talking about. Are you talking about the graphs that's embedded in the critical mention? I don't know what you mean by analytics. Let me make sure I'm clear.
The critical mention analytics reports.
The same analytics reports that you asked for in the second critical mention request?
Only asking you about the first one.
So no. The
No.
answer is no.
Okay.
Not in
Did you give
January.
me any of the critical mention reports in response to this request?
The answer is no.
So the 5 categories, correspondence emails, contracts, payments, analytics, and reports, you did not give me any of those 5.
I gave you 44 pages.
So now we'll move to the second request. So when I got those 44 pages and was not happy with the response, I filed a follow-up open records request. Would you agree with that?
Hang on, Ms. Merchant, to my point about argumentative, right? This is further complicated by the fact that you're also your own witness. And so your questions are not only tending to be argumentative, but filled with facts that haven't been established yet. So
Okay, and that was
work on that.
and I was drawing from what he said about me.
Then reference the document. I think that'll be a cleaner way to keep the record clear. That way we know it's a fact that's in the record.
That same day, January 18th, now I'm talking about that second open records request. I followed up and asked for more documents, correct? I'm just asking if I followed up and asked for more documents.
May I answer this question this way? You pointed out the 5 categories. Thank you for doing that, okay? In your second open records request, you asked for not more, the same documents in one. To me, that was interpreted as you have satisfied my open records request, so I cannot say if you was unhappy. However, of those 5 things, there is one thing in here that you're missing. Can you respond to that one thing?
So let's talk about that second open records request. So I submitted another open records request and asked for more items, correct?
You asked on that second open records request for the analytics graphs. That was also asked for in the first open records request.
And was not provided in the first open records request.
It was not provided, well, based on my review today, no, it was not provided.
And it was also not provided in response to the second open records request.
So on the second one, a response was provided via the Open Records Act. That response on January 26th, footnote 1 reads, no, on January 26th, I don't know what subsection said, essentially, forgive me legal terms, I don't know what you're talking about. Your response, your ask is not reasonably calculated to put me, the business record custodian, in a position to know what you're talking about. At that time, I did not know what analytics graphs were. I didn't know what you were talking about. So you can reference my letter, which I addressed this second open records request personally because it was elevated to me.
I will in a minute, but let me re-ask my question.
Okay.
Did you provide me any analytics in response to my second open records request?
I provided you a response.
Did you?
In my response,
Hang on.
there was,
Hang on. She's asked you a yes or no question. I think you can answer and then explain.
yes, ma'am.
Thank you.
No, I did not give you any documents. I did give you a response. That response said, pursuant to OCGA, Open Records Act, that it is not your request, as stated, is not reasonably calculated to put me in a position to know what you are talking about.
On January 24th, I sent your office a letter talking about this open records request again, the critical mention, media monitoring data. And that's at Merchant 0083. If you want to take a look at it, we'll have it up in a minute. Do you recall receiving that letter?
I recall receiving a letter from you, but I do know that that letter was not exclusively for critical mention.
That's correct.
Okay.
That's
Just
not my
making sure.
question. My question is, do you recall receiving that letter?
Yes.
So let's look at what section of it talks about critical mention. I was following up, and this was asking to please not have to go into a lawsuit, right? That's what this letter was.
I don't know what this letter was, but I do recall seeing it. I don't know if it was a please not going into this lawsuit.
So it was entitled Numerous Outstanding Open Records Requests and Notice of Potential Official Complaint and Potential Civil Action. Do you recall that?
I don't recall the title, but I do recall receiving the letter.
Okay. And you recall generally the contents of the letter?
Yes.
And specifically, let's talk about the critical mention. I asked, and this is on Merchant 0083, I outlined again what I had been asking for,
Yeah, this
and
horrible,
provided even more context.
this painful, long drawn out testimony is almost over. Give us about 4 more minutes, and then we'll go ahead on and continue what the judge ruling is.
In regards to these emails, analytics, things like that. Do you remember receiving this?
I do.
Okay. And you responded, and this would be merchant 0087, if you want to pull that up. This is a letter you referenced earlier. So this is the letter you're saying is from you, correct?
Yes.
It's not signed and it doesn't have your name on it, but you're saying that this is your letter.
Yes.
You drafted this letter?
Yes.
And
What was the page number of that? I'm sorry.
sorry, it's merchant 0087
Thank you.
through 88. The only name on this letter is Fani, correct?
You have to show me that.
Is the only name on this letter Fani Willis?
Are you referring to the letterhead?
I'm referring to someone who received this letter, who think it came from.
Okay, well, I'm going to stop you there because that calls for speculation. But if you could go to the bottom of the document, maybe we could see who signed it. Thank you.
And we just talked about nobody signed it. On the next page, 88, you know that you did not sign it, correct?
I will have to see the second page.
You can pull up the next page, it's 88. Here, fine.
I would believe it was the Open Records Unit or Division or Open Records, sincerely Open Records.
Okay.
So did I sign it? No. But did I draft it? Yes. Is it from my team? Yes.
Looking at these 2 pages, the only name from your office, someone reading this would see is Fani Willis, correct?
You would see the only name in her letterhead. Yes. It's any correspondence, I believe, that comes from the portal on any letter is going to have her letterhead on it.
My question is just, that's the only name that's on that document.
I feel like the document is what the document is. Let's move on.
Okay, thank you. This is your response that you were talking about, and just in regards to critical mention, well, actually not just in regards, let me back up for a second. This letter, you said, despite consistent communication, that I was implying that you were still in violation of the open records, and you disagreed with my disingenuous implication.
Because it was. Yes, I made sure that I let you know that you are disingenuous, and any implication that I violated the Open Records Act was as such. That was my word choice.
Okay, so the first request, the 5 things I asked for, you didn't give me any of those 5 things, and we've established that.
When you say you,
Your office,
my office gave you responsive documents on January 18th.
right? Some responsive documents with the 5 categories, and we agreed to that. The 5 categories, you said, no, you didn't give me the contracts. No, you didn't give me.
When you say you, my staff gave you responsive documents. Okay, we have already said that
Lord.
certain things get elevated to me. You received the records. When you did a second open records request for critical mention of those 5 things, as we have said, you have addressed one. That one thing was brought to my attention, and I handled that one thing. So my assumption, okay, to be clear for the record, was that the first open records request, you received everything. I did not know what was in the 44. You did not, when you brought it up the second time, you did not make mention, right, of anything outside of those 5 things. You only made mention of one. So I dealt with that one thing.
Woo! Man, oh man, oh man, oh man. That was horrible, y'all. And that wasn't the end of it. But Judge Krause did make a decision for her to pay up. And she said the evidence at the hearing also demonstrated that Mr. Bond failed to produce or meaningfully inquire about numerous non-disclosure agreement based on his unnecessarily limited interpretation of the request as pertaining only to media agreement. After Mr. Bond consulted with the defendant's counsel, Mr. Bond understood the request to include confidentiality agreements and produce 22 such agreements. Later, An office-wide email was sent, and numerous other agreements were identified and produced. So I guess that's the 190 something when originally they gave 40 something, right? Mr. Bond also testified he did not conduct any search or make other meaningful search efforts in response to the plaintiff requests for promotional and rebranding materials, claiming he did not know what the request sought and there were no searches to perform. Considering Mr. Bond's testimony and the record as a whole, defendant acted without substantial justification under OCGA 50-18-73B in failing to comply with the ORA. Defendant's failures were intentional, not done in good faith, and were substantially groundless and vexatious. Relief. Because defendant lacked substantial justification for failing to comply with the ORA and no special circumstance exists, plaintiff is entitled to attorney fees and litigation expense, as well as injunctive relief, compelling defendant to provide certain public records. OCGA 50-18-73A and B. Attorney fee. At the hearing, plaintiff offered without objection testimony of affidavits of Mr. Merchant, and their paralegal, Sarah Bergdorf, in addition to itemized record of the work performed and affidavit as to each employment background and experience. In this case, plaintiff charges an hourly rate of $300 for work performed by each attorney and $60 for work performed by Ms. Bergdorf. Plaintiff claims total fee of $54,264 based on Ms. Merchant's 78.7 hours of work on the case, Mr. Merchant's 89.1 hour of work on the case, and Ms. Bergdorf 65.4 hours of paralegal work, amount supported by this respective timesheet. Plaintiff also provided without objection its expense summary and associated receipt for filing fee, service fee, mailing and postage fee, and other expenses incurred in connection with this case, a totaling $1,339.23. Fees and litigation expenses sought by plaintiff, except as otherwise noted, are reasonable, necessary, and justified based on the attorney's and paralegal professional experience. And in the context of this case, its litigation history, accordingly, the court award plaintiff fees and expenses totaling amount of $54,103.23. All right, I'm not going to read all of this here, but the conclusion, let's just go in conclusion. Based on the foregoing, the court hereby enters a final judgment in favor of the plaintiff and against defendant, and orders as follows. 1. No later than 30 days from the entry of this order, defendant shall file a notice of compliance with the court, certifying under oath that the defendant has complied with this order by A. Performing appropriate search of all employees' email and DA's office files and records to ensure that all potential locations for responsive document are searched using available Fulton County information technology resources. B. Providing to the plaintiff all responsive material without the redaction, alteration, deletion, without any deletion. Don't delete anything or modification in any form except as necessary to protect sensitive information like, Social Security numbers and stuff like that. In accordance with the Uniform Superior Court Rule 36.17 and C, explaining in detail efforts undertaken to locate responsive document and detailing searches conducted, including identifying emails to individuals and or DAs, office-wide emails, and as a reasonable or necessary regarding to the existence of responsive material. 2, no later than 30 days from the entry of this order, defendant shall deliver plaintiff payment in a total amount of $54,103.23. And plaintiff shall be entitled to collect in post-judgment interest pursuant to OCGA 7-4-12. Number 4, if defendant failed to comply with any of the terms of this judgment, the court may award plaintiff attorney fees and expenses incurred in obtaining defendant's compliance. This court retains jurisdiction and efforts and enforce in compliance with the terms of this judgment. So it is ordered. The 14th day of March, 2025. The Honorable Judge Rachel Cross, Fulton County Superior Court. All right, y'all. So you guys heard the testimony of Mr. Bonds, and you heard the judge's final decision on this. Yeah, that was done yesterday at 11. What time was it? 11. Hold on. I'm looking for the time. Where did I put it at? 11:48 a.m. yesterday. That was filed with the clerk's office, county clerk. But that is it for now, y'all. I have to come back. I have two stories to tell you about. I'm going to go and talk about Mr. Nichols' arrest, his free world charges. I'm telling you, the YSL group, it can't get a break, y'all. They cannot get a break. And also, Mr. Steele is on a new case, a new controversial case that I'm going to be talking about. I'm going to do both at the same time. Well, Mr. Steele is on a controversial case that we're going to talk about. Merchant is on that case too. They got a dream team on that case. We'll talk about it in a few. I'll see you guys later. God bless y'all. Love y'all. Thank you, everybody. Thank you, everybody. Those who have not hit the like button, please hit the like button. Those who are not subscribers yet, go ahead on subscribe. I got some information coming to you guys. Okay? Do y'all want to know what case that Mr. Steele is working on? Come back and I'll tell you all about it. All right? See you guys later. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night.
the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night.